I'd like to introduce our speaker today, Ed Zetlin. He's an elder law attorney, and he's going to talk about executors, agents, and trustees. And I'm turning it over to him now. Please use the chat, and we'll get started.
All right. Well, thank you, Elizabeth. And I'm happy to come here today and discuss with you estate planning. I do elder law, long-term care planning, and I do basic estate planning. And I think if someone needs to call me, Elizabeth will put some contact information in the chat room. But I work in Falls Church. My area that I work out of is Northern Virginia. And today, we're going to kind of talk in more detail about executors, agents, and trustees. Okay, each of but before I get into what each of these mean, I want to talk in a general way about executors, agents, and trustees. That's really kind of the most important thing, and that is that if you become an executor under a will, or you're an agent under a power of attorney, or you're the trustee of a trust, all of these are people that we call fiduciaries, okay? Now, a fiduciary has legal duties and requirements. It's in the law, okay? And that means as a fiduciary, you act for the estate, you act for, if you're an agent, you act for your principal. If you're a trustee, you act for the beneficiaries. What does that mean? That means if you're an executor and you have an estate that you've opened up because someone has died with a will, you have access to the estate's assets. That's what the court is appointing you. And the same is true of an agent and a trustee. You have direct access. That person has direct assets to, let's say, other people's money, other people's assets. And if you were to take that money and decide, you know, I have direct asset, I think I'll take that money and I'll go to Tahiti and take a good long vacation. Can you do that? No, you can't do that. You have broken a fiduciary duty, okay? Because an executor, you have the duty to the beneficiaries under the will. So you can't just take the money and do what you want. If you're an agent under a power of attorney, you can't just take the money and do what you want because you have a duty to the principal. Now, and the same is true of a trustee. Now, I'll make some better distinctions as we go along because you could be a trustee of a trust and you could also be the beneficiary, okay? And that's okay, that makes sense. So you can spend the money, if you're the trustee and you're the beneficiary, you can spend the money for yourself. That's not a problem. You can always spend the money for yourself if you are the beneficiary. But assuming you're not a beneficiary, then there are obligations and duties that you have to follow. And if you break those, you could be fired as an executor or an agent or a trustee, and you could be sued if you mishandled the money. So there's some responsibility there. Okay, so let's break down all of these positions in more detail. People get them confused. They get executor confused with agent and trustee. They're different roles. They deal with different kinds of time periods when people need them. So an executor is the person that's appointed in a will. They're appointed in the will to carry out the estate under the will. So a will determines where, when a person dies, where assets go where. And if you're the executor and an estate has to be open, because that's the only way to get assets from the decedent to the beneficiaries, the will appoints an executor, and the executor may very well have to go to court, make an appointment with the probate clerk in Arlington, Alexandria, or Fairfax, or Loudoun, or Prince William, and open up an estate. You go there, you make the appointment. Sometimes it's done online now, and you are the executor. That is to say, there are assets then that you have to get control of the decedent. So the person who did the will has now died, and only now does the executor's authority come into view. So the executor may have to go ahead and open up an estate, collect all the assets from the various accounts that the person had, put them under one single estate account in which the executor has control over, pay bills that the decedent owed, pay bills, and distribute the assets. In Virginia, the court oversees what the executor does. So you have a master you have to be responsible to. And actually, the court in Virginia, we don't have a probate court. We have a special person appointed by the court called the Commissioner of Accounts, who you, as the executor, you must report to, and you must please, and you must get approvals from. So there is someone overlooking your shoulder when you are an executor. Now, we call the person under the will the executor. Suppose there is no will. Suppose the person didn't do a will. They didn't appoint an executor because there's no will. Well, then the court will appoint an administrator. We call that person the administrator. They have the same duties. They have to follow the statute. They have to follow through with the Commissioner of Accounts, do all the reporting that is necessary, and pay bills, provide receipts to the Commissioner of Accounts, make sure that everything adds up, that money coming in equals money going out, what remains, and then account to the court for every penny that's spent or distributed. So there's some duties that an executor and an administrator may have. And again, they're under fiduciary duty. So I can get into that in a little bit more detail later on. An executor administrator may get a fee. There are fees that an executor administrator can get. They're basically based upon the amount of assets and income. It's pretty much set by the court. I can never remember the exact fee schedule, but there exists one. But it's a job. It's a job that has to be done. So that's in general what an executor has to do. Now, I'm sure many of you have questions, and I think before I go into all the details of an executor administrator, I'll kind of wait to their questions. But the main thing is that these fiduciaries, they come alive, they have their duties when someone dies, okay? They only speak, they only come about when someone dies and there are assets that have to get to beneficiaries, okay? Okay. There may be times when when even though there's a will and even though we don't even need to have the court do anything because all the assets are going to go automatically through non-probate. Let's suppose all the assets are held jointly. Okay, so if you are a spouse and your spouse dies, all the assets may very well probably are held jointly, the home, the bank accounts, and so forth. There may not be any need to really probate the will because all the assets are automatically going to go to the surviving spouse. So in that case, even though it's a will, you don't really have to open it up because we only open up the will if that's the only way. We only open up an estate if that's the only way to get assets from the decedent to the beneficiaries. Okay? That's an important thing to keep in mind. Now, what about an agent? Agent has a different role. Agent is not an executor. Okay? An agent is someone who is appointed under a power of attorney, a general power of attorney. Sometimes we call it a general durable power of attorney. And the agent acts when the person is alive, not when the person has died. In fact, when the person has died, the agent under a power of attorney, all of their authority ends upon the death. So an agent is appointed to act for the principal. The principal is you. You are the maker of the power of attorney, and you are appointing an agent under this document called a power of attorney for this person to act for you in all things. They can stand in your shoes and do all things, particularly as spelled out in the document, that you could do. It becomes very important, particularly attorneys like me emphasize the need to have powers of attorneys because at some point in our lives, we may become incapacitated. We may not be able to go to the bank. We may not be able to make decisions rationally. We may have to sign contracts and we don't know what the contract says because we don't have the capacity. Well, your agent under power of attorney can then step in and act for you, okay? They can get control of your assets by going to the bank and presenting the power of attorney and saying, I am the agent. I now need to invoke the power of attorney and have the bank appoint them, recognize them as the agent so that they can pay bills for the principal. They may have to go to investment places, brokerage accounts, and take over. There could come a time when the principal can't live in the home by themselves and needs to go maybe to an assisted living. The agent can then sell the house for the principal. They're allowed to do that under the power of attorney. So it's very important to have an agent appointed under a power of attorney so they can take over, particularly when someone is no longer to handle their financial affairs or make medical decisions. They may have such a state where they can't make medical decisions, and the agent under a medical power of attorney has to communicate with the hospital people, the doctors, the nurses. They're appointed under a medical power of attorney to make the medical decisions on behalf of the principal. Okay, the principal is the person who makes the power of attorney, choose who the agent is, and then relies upon the agent to act for them, particularly when they can't act for themselves. Okay, so there's a lot of power under power of attorney. I mean, if you have, an agent may have now access to all the person's assets and can spend money because the financial institutions recognize them to do that. That's a lot of authority and power that you have. And the court generally is not going to oversee an agent under power of attorney. There's no accounting that necessarily comes with it. The court doesn't review it. The agent still has a fiduciary duty to act for the principal. They can't take the money and run off and spend for themselves, that's a violation of their fiduciary duty. But they're generally, there's no power of attorney police, let's say. Now they can be fired. The principal can find out that they're doing something bad and fire them, or someone can say the agent is doing something bad and bring a lawsuit against the agent saying they've broken their fiduciary duty. That's possible. So there is that, but generally the court is not kind of overseeing every distribution and everything that's done. So, and we like to think of an agent under power of attorney for both financial and for medical things. Okay? We think we want someone appointed for both. Okay? So that's the general definition of an agent. Agent gets appointed under the power of attorney. That's when the agent is appointed. Executor is appointed under a will. And you can see the two different time periods. Let's say you're the agent under the power of attorney and the principal dies. I've already said the agent's power ends when the principal dies. Well, then who's in charge of the assets? Well, now you have a decedent. And if there's a will, the executor gets appointed and becomes the administrator of the estate, or if there's no will, an administrator is appointed by the estate, by the court, to manage the estate. The agent, now they could be the same person. The agent under the power of attorney may also be appointed an executor in the will. That's fine. You can play that, but it's a different role. Okay? An agent acts under the power of attorney. Power of attorney is alive and speaks when the person is alive, but probably incapacitated. The executor comes in upon the death of the decedent and becomes appointed under the will as the executor. Okay? Trustee. Well, you can guess what document goes with a trustee. That's probably not a hard guess. It's with a trust. So a trust doesn't appoint an administrator or an executor. A trust doesn't appoint an agent. A trust appoints the trustee. Okay. So a trust is different than a power of attorney because a trust is a document generally prepared by attorneys. We have somebody called a grantor. That's the maker of the trust. So the grantor makes a trust. They are the grantor. In that trust, they're saying who is the trustee, and then they're saying who is the beneficiary. Okay? So I, Ed Zetlin, I say I want to have a trust. Or me and my wife and I decide we want to have a joint trust. We are the joint grantors. And in our trust, we appoint a trustee. Guess who the trustee is? My wife and I. We, the immediate trustees, and we are also the beneficiaries while we're alive, because it's our money for all the assets in the trust. So we are the grantors, we are the trustees, and we are the beneficiaries. But there's more. In the trust, there is provisions that say what happens if the original trustees, myself and my wife, become incapacitated. Well, in the trust, there is a successor trustee. And it says, if I and or my wife are incapacitated, then the successor trustee takes over. And they manage the assets in the trust that have been placed in the trust. So you actually retitle assets in the trust. You retitle your house into the trust. You retitle your brokerage accounts, your bank accounts, all in the trust. And the trustee is in charge. They write the checks, they pay the bills, they make distributions. So Now my wife and I, who are the original trustees, we've become incapacitated and we've appointed a successor trustee. My adult daughter is the successor trustee. She has an obligation under fiduciary duties to use the funds in the trust, not for herself, but for her parents, who are no longer the trustees. They're the beneficiaries, and she must use the money in the trust to take care of her parents, pay their bills, so forth, pay the assisted living, all that stuff. Okay? So then that's what the trustee does. And then if one spouse dies, the trust continues for the benefit of the surviving spouse. At some point, the surviving spouse will die. My daughter is the trustee. She remains the trustee after we have died. After we have died. It's all our money. In that trust, when I originally created that trust as a grantor, I said where our money goes when both myself and my wife dies. I said I pointed out where that money goes. Guess where it goes? It goes to my daughter. So now she is the trustee because we're gone. The parents, the original grantors are gone. She still is the trustee. And under the trust, she can now, since the trust says all assets remaining in the trust upon the death of the grantors goes to her, she can end the trust and pay herself all the trust funds that exist in the trust. Or she has to pay any final bills, but she can pay herself. Then she can pay herself because now she's not only the trustee, she's the beneficiary. The trustee said upon the death of the grantors, my daughter is the beneficiary. Now, may not have said that. It may say, I just did a trust for a man who doesn't have any children and doesn't have a spouse. He wants to leave part of his money to his brother and he wants to leave the other part to a charity. So if he dies, he's the original trustee. His brother will then become the trustee who takes over upon his death. And then that his brother then, let's say there's $1 million in the trust. Well, it says half the money goes to his brother, so he writes a check to himself, and the other half goes to the charity. He writes a check to the charity and closes the trust. Now, it'd be illegal for him to take the $1 million and write himself a check for $1 million. He would be breaching his fiduciary duties because there was another beneficiary other than him, the charity. So he has to do that. Generally, however, I will tell you that the court is not overseeing a trust. In fact, that's one of the reasons why we do trust, so that the court doesn't oversee it. So the court doesn't oversee it. And we are based upon the idea that the trustee is going to do what the trust says and follow the directions in the trust. Okay, that's why it's called a trust. Got to trust the trustee. So it's important to have a trustee that you trust and that it's going to do the right thing. And that same is true for the agent and, of course, for the executor and for the administrator. That's all very, very true. There are two roles of fiduciaries that I didn't point out. I'm going to just speak to them about very briefly now. Sometimes when there is no power of attorney and no power of attorney for financial and medical decision making, and a person becomes incapacitated, a guardianship and or a conservatorship has to be filed in court to appoint somebody who is the guardian and conservator for that person because they can no longer make decisions. But they never did a power of attorney, so there's no agent. So when a court appoints a guardian and or a conservator, the guardian is in charge of the personal decisions, where you're going to live, what kind of medical treatment you're going to get, and so forth. The conservator is the person in charge over the assets of the person. Those two people, those two rules also are fiduciary positions. Now, they are overseen by the court. There are rules when the court oversees a guardian and a conservator. So the court oversees those people. They are fiduciaries. Their powers end when the person dies, just like the agent under power of attorney. That ends. But they have duties to make decisions for the incapacitated person, and they're overseen by the court. So now you got even more terms. Now we have executor administrator when the person dies. We have agent. We have a financial agent and a medical agent. And then we have a trustee under the trust. And now we have other fiduciary terms, a guardian and conservator. Hopefully, if you've done a power of attorney, there'll never be a need for having a guardian or conservator appointed for you, because you've done something yourself so that no one ever has to file a guardianship or conservatorship. So that's why it's very important to have a power of attorney, both for financial and medical reasons, so that somebody can manage your assets when you become incapacitated. So I've spoken for about, about almost 30 minutes. I want to stop now and open up for questions. I have more to talk about, but I just wanted to take a breather because I'm getting a little tired of hearing myself talk, and try to take some questions from anybody about anything we've talked about an executor, agent, a trustee. Anybody have any questions? You can put them in chat. Can you discuss the advantages and disadvantages of having more than one executor or trustee? What do you recommend? Okay, good question. I didn't talk about this. So for the executor, you want to appoint an executor, but suppose the executor dies or becomes incapacitated. You want a successor executor. So I think in all these documents, in your will, in your power of attorney, in your trust, you need to appoint successor executors, agents, trustees, in case something happens to the first appointed executor, agent, or trustee. Now, can you have joint executors, joint agents, joint trustees? Well, it's possible. I think that it's probably not a good idea, particularly for a will, to have a joint executor, because that means they have to do everything together, and that's a real pain in the rear end. So I do not think it's good to have a joint executor, okay? As a general rule, it's not a good idea. How about for a financial power of attorney? We often do powers of attorneys. We can do power where we appoint joint agents. I think it's better to have a single agent and then backup agents for under the financial power of attorney. For the medical power of attorney, you could get away with having a joint agent, provided that those agents are going to agree. So you want to appoint all your 3 children to be able to make medical decisions. That's fine, provided your children, when you become incapacitated, are not going to fight amongst each other. Otherwise, if they do, you want to have, you may not know, you want to have a primary agent and then successor agent. And by the way, you can have a successor to the successor. That's okay. A trustee, well, remember, me and my wife, we're both joint trustees. That's fine. We can be joint trustees. But then I've named a successor trustee after us. I don't think it's I think the grantors can be joint trustees. That's very common. But after that, I think it's a better idea to have one successor trustee. Okay. So that's my rule of thumb. Rule of thumb, as a general rule, it's better to have one agent, one trustee, one executor, and then appoint people who can follow up after that. That's my general rule of thumb.
Okay, next question. Why do you need a medical POA if you have an advance directive? How do they differ?
Well, an advance directive, depending on what's in it, and a medical power of attorney are kind of the same thing. So an advance directive, in its general sense, does two things. It appoints an agent and it says what happens to you upon your death. So advance directive contains a medical power of attorney in it. Okay. And then it says, if I should have this condition, I don't want my agent to keep me alive. Okay. That's a general term. The way I tend to do it is I do a separate medical power of attorney and then I have a separate advance directive. Now you can, as I said, many people combine those. That's fine. I simply do them separately and that's okay too. I hope that helps. So a medical power of attorney appoints an agent. And then there is when I say an advanced medical directive, I'm talking about kind of like a living will. We don't call it a living will, we call it an advanced medical directive. So an advanced directive has a medical power of attorney and it has an advanced medical directive. Has both those things. Okay. Combined. That's all. That's just the difference. Next question.
Okay. Can the executor pass through a mortgage on inherited property if a beneficiary wants to do so?
They could assume the mortgage. They certainly could assume the mortgage. They may have to assume the mortgage if the beneficiaries inherit, or they may need or inherit the properties. They could. They could say, okay, we're now owning it and we will now pay the mortgage on it. Okay. So they could assume the mortgage. It's really up to the mortgage company what it wants to do. They might decide, well, let's refinance the property and get a better mortgage. They can do, get another loan and pay it off. So there are various ways of kind of handling it that. It's also possible that the will says, I want the property to be sold. That gives the agent a power of sale to sell the property, pay off the mortgage, and then do everything else. So that's kind of how it works. In fact, if there's no power of sale authority, the executor or administrator has to go to court and get a power of sale. That is, they have to get authority from the court to sell the property. I am an administrator now for an estate, and there's no way for the beneficiaries to be able to pay off the mortgage or assume the mortgage. I went to court and got a power of sale. As the administrator, I'm going to sell the house. And then I'm going to distribute it to each of the beneficiaries. Because I don't think either one of the beneficiaries could assume the mortgage. Okay, next question.
Okay, that's it for the questions in the chat right now.
The chat. Oh. Any other questions right now? Everything is clear. I cleared up all the different questions. Should we have a quiz? Shall we have a quiz? So does an agent's authority last when the principal dies? Can the agent still act? What's the answer? The answer is no. So if you're an agent and your principal has died and you go to you write a check after they've died You can't do that. Your authority ended. You can't do that. Okay? You can't go to the bank and make a deposit. Your authority as the agent. In fact, if the bank knows that the principal has died, they're going to say you can't act anymore. You're done. So
Okay. So we do have some more questions that came in, and
okay.
someone did answer correctly. How often do you have to update your documents?
Well, there is no real rule. I think one is, number one, when something big has changed. So certainly if a beneficiary has died, or the agent has died, or primary agent has died, then it's probably a good idea to update the documents. People do documents, for instance, they'll do an estate plan when their children are young. And then when they get older and their children are grown, they'll do a new estate plan. Okay, they'll do a brand new estate plan. Now that the estate planning we did in case they died and we appointed guardians for the children, we don't need that anymore. The children are all grown. So that can make a difference. And when big events occur, as I described below, it's good to review and update your documents. Sometimes when the laws change, it's a good idea. Other questions?
Okay. Someone wanted to know if you could talk about irrevocable trust.
Irrevocable trust. Okay. So the difference between a living trust and an irrevocable trust is, as you can guess, a living trust can always be revoked. You can always say, forget about the trust, I revoke it, I don't want to have a trust anymore, I pull all my money out of the trust, that's it. I want it just in my name. That's a revocable trust. The IRS, when you do a living trust, the IRS will treat the income that the trust makes just as it was before you did the trust. It makes no difference to the IRS because it's irrevocable. Okay. An irrevocable trust is what you say. You can't simply revoke the trust. It's irrevocable. You have made an irrevocable contract and you can't revoke it. Okay? An irrevocable trust will have a separate tax ID. Okay? It'll have a tax ID that you get from the IRS. And it'll be on its own separate tax schedule. Irrevocable trusts are taxed differently than a living trust. In fact, the living trust is not taxed at all. An irrevocable trust is taxed, and it's taxed at a much compressed form. So that's the basic definition between a living trust and an irrevocable trust. So why would you do an irrevocable trust? Well, there are various reasons. I often sometimes do irrevocable trusts if I'm doing Medicaid planning. So I do elder law, I do some Medicaid planning, I do something called a Medicaid Asset Protection Trust. We may want to irrevocably put the house in an irrevocable trust and hopefully wait 5 years. And then if the person, the grantor ever needs Medicaid, the house in the trust, even though they still live in the house, they don't really own it. It's owned by the trust. 5 years have gone by and there's no transfer of asset penalty because the 5 years have passed. So I sometimes do irrevocable trusts for people that want to do that kind of Medicaid plan. And I do that. There are some other reasons why people do irrevocable trusts. Sometimes people do for credit protection. A revocable trust really doesn't give you a whole lot of credit protection, but sometimes people do an irrevocable trust for credit protection. And there are other reasons. So that's the difference. Other questions?
Okay. If you don't put your IRAs in the trust, how do they get distributed if your successor trustee is a trust organization?
Well, you have said in your IRA, when you die, where your IRA money goes. You've done a beneficiary designation. So you could have said to my IRA, to my spouse, and if my spouse predeceases me, to my children. You don't have to put it in the trust because it all goes by beneficiary designation. Now, suppose you wanted to leave your IRA to a charity. You can do that. You could say, when I die, this IRA is to go to this charity. Or you could say, when I die, this IRA is to go to the trustee of my trust. And then the trust says, everything in the trust goes to a charity. So that could be done also. But generally, things like IRAs have a beneficiary designation, and it doesn't necessarily have to go to the trust. You may want to have it go to the trust. You may want to have an IRA going to a trust, particularly if you have minor children. And the minor children, would otherwise need a guardian, and you decide, well, I'm going to have, if I die, my IRA is going to go into my trust, and my trustee is going to manage the distribution of the IRA to my children through the trust. That's possible. I hope that's not too confusing. But generally, IRAs go by beneficiary designation. Most of my clients, they're older, they've got IRAs, it's going to go to their spouse, they've got grown children, it's going to go to their grown children. And it's going to go by beneficiary designation.
Okay. What is the difference between the power of attorney and the power of appointment?
Oh, the two are not the same. A power of attorney is where an agent has authority to act for the principal. Okay. A power of appointment is a way in which you, as the owner of the assets, can say, I have decided to change where my assets in my trust go to when I die, and I'm now using this power of appointment to appoint that it's to go to these people. So power of appointment is used by the maker of the document, the person who is to say where assets go upon their death. It's a way of kind of changing beneficiaries under a will or a trust, or making final decisions. That's what a power of appointment is. It's not the same, it has nothing to do with being an agent under power of attorney. Power of attorney is simply the ability of someone to act when someone becomes incapacitated. That's not a power of attorney, is to direct assets where asset goes upon my death.
Okay, next question is, if one has no relatives, where would they find expert needed to help when their health begins to fail?
Good question. Very good question. Well, if there is a trusted friend, someone who you would really trust and is younger and healthier and is willing to do that, that could be a good fiduciary if they're willing to do that. Okay, that's number one. Yeah. Number two, you can ask sometimes law firms. We don't volunteer this. We don't go around saying we want to be your fiduciary. But if for instance, clients don't have anybody and they say, would you consider being my agent, or would you consider being my executor? I can do that. Attorneys can do that. There's some rules that we have to follow, some very important rules. There are other documents we can find. We can't thrust ourselves, but sometimes attorneys like myself can serve as agents, trustees, executors. Okay? Provided we follow the rules that the state bar has has put out with regard to ethical issues. So we can be fiduciaries, but we have higher ethical things that we have to meet.
Okay. Another question, don't living trusts become irrevocable on the death of primary
That is a
trustee?
good point. That is true. That is true. When you die, your trust, the grantor dies, the trust is irrevocable, right? Well, think about this. The only person who could revoke the trust is the grantor. The grantors die. The only person who could change the trust is the grantor. The grantor is now died. Nobody can revoke the trust. Nobody can change the trust. The trust is irrevocable. That's true. That's a good point. I didn't think about that. That is a very good point. But stands to reason a trust becomes irrevocable upon the death of the maker of the grantor. Yep, that's true.
Okay, any other questions at this time? Okay, well, we have answered all the questions, and I hope everybody now understands the difference between all these responsibilities. And I want to thank everyone for joining us today, and hope you will join Ed on another session next month. And everybody enjoy their day. Thank you so much,
Have a
Ed.
good day. Thank you all.